guys, welcome to DJure. The question can come regarding the definition of functional method in comparative law, and you can explain that with some relevant practical examples. So let's start with the definition of functional method. So the functional method is most widely used approach in comparative law. It was systematically developed by Conrad Zwigert and Hein Kortz in their work An Introduction to Comparative Law. According to this approach, different legal systems they may adopt different rules, but they are often designed to solve the same problems. So the problems may be same social problems, but different rules and different approaches are used to solve these problems. Instead of comparing only the wordings of these statutes or the codes, the functional method, what it does, it examines the function of the law, what it is trying to achieve in practice. The main idea of the functional method is that if the two legal systems they face the same problem, the solutions they may look different, but functionally they are often comparable. Let's study about the features of this method now. Firstly, this method is problem oriented. It focuses mainly on identifying the legal problems first. For example, Consumer Protection Act, where we study about the problems of the consumers through different approaches. Then there is liability for negligence. Here again we understand the liability for negligence from different perspectives of different countries. So this is obviously often comparable. Second feature is solution based. So it examines how different legal systems they may resolve that problem, even if the terminology or the structure of finding that solution it is different and it differs. Third is neutral perspective. So the third feature of the functional method is neutral perspective. This means that it avoids the value judgments. Basically what it does, it seeks to understand effectiveness rather than superiority. Okay. Next is practical utility. So what it does is the functional method, it helps lawyers and the judges to borrow workable solutions from other jurisdictions. So it aims towards practical utility. So there are four features of the functional method that we have discussed. First is it is problem oriented. Second, it is solution based. Then it is neutral perspective. It avoids the judging and making value judgments and focuses more on effectiveness. Then there is practical utility. These are four important functions. Next, we will talk about its practical relevance with some examples. So there are a few perspectives we can look for practical relevance. Firstly, the functional method, it is highly relevant in today's globalized legal world because of mainly law reforms. So that would be our first relevant point, would be law reforms. So legislators, they often study foreign models to reform domestic law. Example, India's Consumer Protection Act 2019, it protects against unfair trade practices. Whereas US has the same act in the form of US uses the Federal Trade Commission Act. Whereas European Union, it uses the Unfair Commercial Practices Directive. Through different acts, they are basically solving the same problem of reforming domestic law against trade practices. So though the text of these acts they differ, functionally all three regimes they seek to protect the consumers only. Okay, the second point of view that we will study is through judicial reasoning. So the courts use this functional approach in interpreting rights and legal principles. For example, in the case of Justice K.S. Puttaswamy versus Union of India, which was a landmark case in 2017, the Supreme Court in this case, it recognized the right to privacy as a fundamental right after examining how US, UK and EU courts they deal with this issue. So how they have dealt with the issue, accordingly this judgment was also passed by Indian Supreme Court in their context. So this is the perspective of judicial reasoning and you can use this example. Third is international harmonization. So this can be studied in the way of, this method is used in drafting model laws and treaties. For example, in UNCITRAL model law on arbitration, what India did is it adopted this UNCITRAL model, it adopted India's Arbitration and Conciliation Act of 1996. Though arbitration rules here differed worldwide, the functional method, it harmonized them to ensure efficiency in resolving the disputes. So that helped in dispute resolution mainly. Then we can use the approach of legal education research. For till now we have studied law reforms. Then there is judicial reasoning. Then in the context of international harmonization, now we are moving forward towards fourth perspective when it comes to practical relevance of this functional approach, functional method. So fourth would be legal education research. In this context, this functional method, it helps scholars, they classify the legal systems not by rigid categorization but mainly by how they function in practice. So basically it encourages the interdisciplinary research linking law with different fields such as with economics, with sociology and with politics. Okay, so the functional method is basically, you can conclude this answer, you can write all these main points. Firstly, about its definition, and then its four important features that we have studied: problem oriented, solution based, neutral perspective, practical utility, and then moving forward with practical relevance with various examples in different perspectives. You can write about law reform, then judicial reasoning, then international harmonization. Obviously, with examples, otherwise without examples your answer will not be complete. You have to back them with examples and good references. Then the fourth would be legal education research. Next, you can conclude this by saying that the functional method is basically what it is. It is the backbone of comparative legal studies because it highlights the practical role of law in solving common problems across different societies. For example, for India, it has been crucial in shaping legislation like which all we can refer to consumer protection. Then there is arbitration, and in judicial reasoning we have talked about case Puttaswamy, like privacy, and then you can write about equality. So in terms of India, this is how functional method is helped in comparative legal analysis. Then while it may be balanced with the historical and contextual methods to avoid the oversimplification, but its practical value, it makes it indispensable for law reforms. It is very, very important for law reforms, for judicial practice and global harmonization. So this is overall a very important method. You can write this about the comparative analysis of why functional method, it helps us in doing this comparative analysis between different laws of the world. And yeah, that's it. Okay, thank you. See you in the next video. Stay tuned.